One of the biggest misconceptions in the federal criminal justice system is believing that once a sentence has been imposed, nothing can ever change. Many prisoners and families believe the judge's decision is permanent, that there are no remaining legal options, and that the sentence must simply be served exactly as it was originally imposed. But federal law is more complicated than that. While federal sentences are generally considered final, Congress has created several limited situations where a sentence may later be reduced. That does not mean every prisoner qualifies, and it certainly does not mean every request will be granted. But understanding that these legal mechanisms exist is an important first step. In this video, we're going to explain the different ways a federal sentence may sometimes be reduced. We'll discuss compassionate release, retroactive sentencing changes, Rule 35 reductions, and why understanding the difference between these legal processes matters. And make sure you stay until the end of this video, because one of the biggest mistakes families make is assuming every sentence reduction works the same way. They do not. And misunderstanding the process can lead to unrealistic expectations and costly mistakes. Let's begin with an important principle. Federal sentences are generally final. In other words, once a sentence has been imposed, federal courts usually cannot simply reduce it because someone believes the punishment is too harsh, or because enough time has passed, or because the prisoner has become a better person. Those factors may be meaningful, but federal courts are limited by statutes passed by Congress. Judges must operate within the authority the law gives them. That means a federal sentence can generally be reduced only when a specific legal mechanism allows it. One of the best-known examples is compassionate release. Over the past several years, compassionate release has received significant public attention. Many prisoners have heard about inmates receiving sentence reductions through compassionate release, especially during and after the COVID pandemic. As a result, some families assume compassionate release is simply another name for asking the judge to show mercy. But compassionate release is much more structured than that. Federal courts apply specific legal standards. They consider the facts of each individual case, and they evaluate whether the law allows relief under the particular circumstances presented. Compassionate release is not automatically available simply because someone is elderly, has health problems, or has already served many years in prison. Every case is different, and federal courts carefully review each request under the applicable legal framework. We'll discuss compassionate release in much greater detail in our next educational video. Another situation involves changes to federal sentencing law. From time to time, the United States Sentencing Commission adopts amendments to the federal sentencing guidelines. Some of those amendments may later become retroactive. When that happens, certain prisoners may become eligible to ask the court to consider reducing an existing sentence. But here is where many people become confused. Not every amendment applies to every prisoner. A sentencing change affecting one type of offense may have absolutely no impact on another person's case. Eligibility depends on many factors, including the original sentence, the applicable guidelines, the statute involved, and whether the amendment was made retroactive. Simply hearing that another inmate received a sentence reduction does not mean the same opportunity exists for everyone else. Another legal mechanism sometimes discussed is Rule 35 of the Federal Rules of Criminal Procedure. Many prisoners hear the phrase Rule 35 while talking with other inmates. Unfortunately, it is also one of the most misunderstood areas of federal law. Some people believe Rule 35 allows anyone to ask the judge for a lower sentence whenever they believe fairness requires it. That is not how the rule generally works. Rule 35 applies only in specific circumstances established by federal law. Its availability is limited, and it does not create a general opportunity for sentence reconsideration. Now let's talk about another common misunderstanding. Many families believe every important Supreme Court decision automatically reduces federal sentences, or that every new sentencing amendment applies to every federal prisoner. Unfortunately, federal law rarely works that way. When a significant legal development occurs, the first question is not, is this good news? The first question is, does this legal development actually apply to this particular case? That answer depends on many factors: the statute involved, the procedural history, the sentencing record, current federal law, and sometimes whether Congress or the Sentencing Commission intended the change to apply retroactively. That is why reading headlines online, watching short videos, or hearing about another prisoner's success can sometimes create false expectations. Every federal case is unique. Another important distinction involves post-conviction challenges. Many people mistakenly believe sentence reductions, 2255 motions, and 2241 petitions are all basically the same thing. They are not. A 2255 motion generally challenges the legality of the conviction or sentence. A 2241 petition generally addresses certain issues involving the execution of a federal sentence. Sentence reduction mechanisms, such as compassionate release or certain retroactive sentencing changes, often rely on entirely different legal authorities. These are separate legal processes. They have different purposes, different procedural rules, different eligibility requirements, and different legal standards. Understanding those differences helps families avoid unnecessary confusion. Here's a practical example. Imagine two federal prisoners serving similar sentences. One prisoner may become eligible to request compassionate release because of specific circumstances recognized under federal law. The other prisoner may not qualify for compassionate release at all, but could potentially benefit from a future retroactive sentencing amendment. Another prisoner may qualify for neither. The important point is this: federal sentence reductions are not one-size-fits-all. Eligibility always depends on the law that applies to that individual case. That is why careful legal analysis matters. It is also why no ethical person can promise that a sentence will be reduced. Federal judges carefully review the law, the record, the facts, and the specific authority allowing relief. Education helps families ask better questions. It helps prisoners better understand the federal system. And it helps avoid many of the misconceptions that circulate online. If you'd like to learn more about federal sentence reductions, federal post-conviction relief, or other educational federal relief topics, visit apexfederalrelief.com. And if you found this video helpful, subscribe for more federal relief education explained in plain English, because the better prisoners and families understand the federal system, the better prepared they are to make informed decisions moving forward. And in our next video, we'll take a closer look at one of the most frequently discussed forms of sentence reduction: compassionate release, including what it is, common misconceptions, and what prisoners and families should understand before pursuing that process.